Hello, everyone. I'm Dr. Niki Siabaku, Joint Researcher at TMC Asser Institute and the International Center for Counter-Terrorism, and I'm delighted to welcome you today for the ICCT live webinar, The Role of Transitional Justice in the Context of Counter-Terrorism, Opportunities and Challenges. Thank you very much for being here with us. Before introducing our speaker today, I would like to briefly introduce ICCT to those who are less familiar with our work. ICCT is an independent think and do tank based in The Hague, working to provide research, evidence-based policy advice, and practical on-the-ground solutions on matters regarding counter-terrorism and countering violent extremism, with a special focus on prevention and the rule of law. I would also like to give you a few housekeeping notes to keep this session running smoothly. There will be a short half-hour Q&A session after the panelists have presented. If you would like to ask a question, please feel free to submit it at any time during the webinar using Zoom's Q&A feature. We will try to answer as many questions as we can. Please also note that the recording of the webinar will be made available to all registered participants on the ICCT YouTube channel. Finally, please help us improve future live webinars by completing the very short post-event survey that will pop up on your screen when you leave this webinar. Today's webinar will be focusing on transitional justice and counterterrorism. And I have the honor and pleasure to have here with me today three great speakers and experts on the question to be discussed. First of all, I would like to welcome Bernard Duhaime, the Special Rapporteur on the promotion of truth, justice, reparation, and guarantees of non-recurrence. Bernard Duhaime is a full professor of international law at the Faculty of Law and Political Science of the University of Quebec in Montreal, where he specializes in international human rights and humanitarian law. Professor Bernard Duhaime started his mandate on the 1st of May this year, and he's here to explain his approach to the mandate and his areas of interest for the years to come, which include transitional justice, terrorism, and counterterrorism. Our second speaker for today will be Anne Charbot, who is an international human rights lawyer focusing on counterterrorism and conflict, and she's also a lecturer at Sciences Po in Paris. Anne was a legal advisor to the mandate of the UN Special Rapporteur on Human Rights while countering terrorism and has authored a number of books and articles on human rights law and also an excellent report on the topic of today's session, which we will share with you later. Last but not least, we have today with us Tanya Mera, who is a Senior Research Fellow and Program Lead of the Rule of Law Responses to Terrorist Program at the International Center for Counter-Terrorism. With a background in international law, Tanya is involved in conducting evidence-based research, providing policy advice, advising governments on a rule of law approach in countering terrorism. I would like to thank all of you for being here today to provide your expertise and insight on such an important topic. Our speaker will discuss the possible interaction of transitional justice and counterterrorism. And before I give the floor to the Special Rapporteur, who will be our first speaker, I would like to provide you with a very brief introduction of what is transitional justice for those who are less familiar with this field. So, transitional justice is defined by the UN as a full range of processes and mechanisms associated with a society's attempt to come to terms with the legacy of large-scale past abuses in order to ensure accountability, serve justice, and achieve reconciliation. Transitional justice is important to remember that it's based on 4 pillars, which is truth, justice, reparation, and guarantees of non-recurrence. Regarding the first pillar, which is a pillar of truth, it refers to victims' right to truth, which is today enshrined in numerous human rights instruments. This right refers to an individual right to know the truth about what happened to their loved ones, but also it's a collective right related to national history and heritage. The right to truth in transitional justice is implemented through truth and reconciliation commissions, which are non-judicial bodies established for a fixed period with a mandate to investigate violations that occurred in the past and submit a final report with their findings and their recommendations. The second pillar, the one of justice, refers to the right to justice, which includes the right to a fair and effective remedy. This entails states' obligation to provide for an effective remedy and investigate, prosecute, and punish the perpetrators of the violations. The third transitional justice pillar is the one of reparation, which should be understood as a panoply of different responses to atrocities and wrongdoings and can take the form of restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. And finally, the last pillar, the one of guarantees of non-recurrence, it refers to measures that should be taken to avoid repetition of the human rights violation and abuses, and it often includes measures such as legal, judicial, constitution, and security sector reforms. Transitional justice pillars should be implemented as part of the whole so that they can reinforce each other. And it's important to mention that since the previous Special Rapporteur's mandate, Professor Fabian Savioli, the mandate has a fifth pillar, the one of memorialization, yet it should also be mentioned that this fifth pillar is not universally accepted. The measures of transitional justice emerge first as practices and experiences in post-authoritarian settings, such as Latin American countries of the Southern Cone, and to a lesser extent, those in the Central and Eastern Europe and South Africa. But later, we can see that they were used in a post-conflict situation and even more recently in Western societies. This leads us to the question we are here to discuss today regarding the role of transitional justice in a new context, the one of counterterrorism. And without further ado, I would like to give the floor to Professor Bernard Duhaime, who will speak about his mandate and this new area of interest. Bernard, you have the floor.
Thank you very much. Good afternoon, and thank you everyone for being here. I want to express my gratitude to the Center, to the International Center for Counterterrorism for bringing us together. As I'm been already shared, I've been nominated as the Special Rapporteur on promotion of truth, justice, reparation, and guarantees of non-recurrence as of the 1st of May. So this is beginning my mandate. This mandate operates under the Human Rights Council of the United Nations, together with other UN special procedures of the system. These procedures are independent human rights experts who have the mandate to report and advise on human rights from thematic or a country-specific perspective. Special procedures experts are appointed by the Council and serve in their personal capacity for a term of 3 years, which can be extended to a maximum of 6. They work on a voluntary basis and are independent from any government or organization. Special procedures mandates cover all state members of the UN, irrespective of whether a state has ratified a specific instrument or not. As of July 2024, there are 46 thematic and 14 country mandates. On the 29th of September 2011, the Council adopted Resolution 18/7, which establishes the mandate of the Special Rapporteur for a period of 3 years. The resolution mandates the Rapporteur to examine the measures in the field of transitional justice adopted by governments to address the gross violations of international human rights law and serious violations of international humanitarian law, committed in situations of conflict or of authoritarianism, so during armed conflicts or authoritarian regimes. Since then, the mandate of the Special Rapporteur has been renewed every 3 years, and in 2023, the Human Rights Council adopted Resolution 54/8, which extended the mandate of the Rapporteur for an additional period of 3 years, and mandates the Rapporteur to deal with situations of gross human rights and serious violations of humanitarian law. The resolution assigns 12 functions to the Special Rapporteur, including providing on request technical assistance or advisory services on matters pertaining to the mandate, to gather information on national situations, to identify good practices, to conduct country visits, and to make recommendations on judicial or non-judicial measures in developing and implementing strategies and measures to address gross violations of human rights law or of international humanitarian law. The Human Rights Council mandates the rapporteur to carry out these tasks through regular dialogue and close cooperation with governments, international and regional organizations, national human rights institutions, and non-governmental organizations, as well as relevant UN agencies and mechanisms. It applies a victim-centered approach that is grounded in international law and informed by gender perspectives, transdisciplinary insights, and the voice of historically marginalized groups. It promotes transitional strategies from under the five pillars that Nikki just mentioned, so truth, justice, reparation, guarantees of non-recurrence, and memorialization. Given that many of the world's current or potential transitional contexts involve terrorism and the fight against it, it's easy to imagine how critical today's discussion is. There are many open questions around how effectively design DDR initiatives, repatriate foreign terrorist fighters, account for abusive counterterrorism tactics, and incorporate harms related to terrorism effectively into traditional transitional justice measures, such as truth commissions and reparation programs. How we decide to answer these questions will have an immense impact on how transitional justice processes are constructed and implemented in these places. Accordingly, the fields of transitional justice and counterterrorism should be moving in a lockstep, which requires ongoing dialogue between the two. Today, I would like to share how I intend to foster such dialogue through my mandate. As you may know, my work includes conducting country visits, holding formal and informal dialogues, participating in events, providing technical assistance, sending communications to national governments, and writing annual reports to the Human Rights Council and to the General Assembly. My first two reports identified 10 priority issues areas that I would like the mandate to explore over the next 6 years. Whereas the 5 themes that I presented to the General Assembly last week are more substantive in nature and deal more with public policy related issues, the 5 themes that I presented to the Human Rights Council in September are more technical, legal, and methodological and pertain more to the mandate itself. I intend to dedicate an annual report to each of these areas within which I will examine existing successes and obstacles and recommend policies and best practices. My overarching goal is to promote the most comprehensive, victim-centered, and sustainable transitional justice processes possible. 5 of these areas have a substantial overlap and interaction with counterterrorism, so I will be describing these in more detail for you now. However, I want to highlight that the topics that I will not be addressing, which include economic, social, and cultural rights, documentation practices, early implementation, transgenerational impacts, and bottom-up south-north approaches within transitional justice, all could be better understood with insights from the counterterrorism field. As such, I invite your feedback on all of those issues as well. Starting with substantive themes, so those that I presented to the General Assembly last week. There are 3 themes that I believe are particularly relevant to the counterterrorism context. First, I intend to examine transitional justice's response to mass human rights violations. My mandate focuses strongly on violations of international human rights law and serious violations of humanitarian law within the context of armed conflicts and authoritarian rule. However, there are several sources of massive human rights violations that both exacerbate and are exacerbated by conflict and authoritarianism, including forced displacement, mass migrations, climate change and environmental crimes, corruption and organized crime, and most importantly for this discussion, terrorism and counterterrorism. Transitional justice has yet to fully account for the effects of these phenomena and how they have impact on the lives of millions of people. And I submit that adapting transitional justice systems to recognize and respond to the suffering, this suffering could better resolve root causes of the violence and promote and prevent its recurrence in the future. I also hope to recognize in my work that these phenomena result in the widespread rights violations even outside post-conflict and post-authoritarian settings. And transitional justice can offer critical lessons regarding how to address them. Given that I intend to directly address and study violations committed in the course of terrorism and counterterrorism under this priority, it is the area where I would benefit the most from the research, experience, and expertise of many of those joining today. In 2023, deaths from terrorism rose 22% despite a drop in the number of attacks, with the epicenter of activity shifting in recent years from the Middle East to the Sahel in Africa. In addition to death, terrorist activity entails other grave human rights violations that mirror those seen in traditional transitional justice contexts, such as enforced disappearances, detentions, sexual violence, torture, and forced displacement, often linked to discrimination, as well as increased society instability and potentially weakened governance and institutions. These violations often rise to the level of international crimes, including crimes against humanity and war crimes. In Iraq, the crimes of Daesh have been legally recognized as constituting genocide. Nearly all of the states with the highest terrorist activities are classified as being in armed conflicts, either within a terrorist organization, with a terrorist organization itself, or with other state actors or non-state actors. And terrorism generally has become increasingly transnational in modern era, both factors that broaden the scope of harm. Relatedly, abusive counterterrorism actions by states have led to widespread human rights violations, including death, torture, and rampant due process violations, many of which have worsened rather than remedied over the past 2 decades, according to the most recent reports by the Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism. Many of these concerns relate to anti-terrorism laws that are leveraged against human rights defenders and other members of civil society. The previous mandate holders have expressed serious concerns over violence perpetrated by terrorist organizations and the wrongful weaponization of purported counterterrorism measures in reports, country visits, and communications. Given the widespread human rights violations and societal risks that both cause, as well as the relevancy of transitional justice pillars to societies seeking to respond to them, transitional justice is a fitting approach. The UN Secretary General, Special Rapporteur on Counterterrorism and Human Rights, and the previous mandate holders have recognized the positive potential for transitional justice, with a particular focus on preventing recurrence through establishing security sector and legal reforms to address abusive counterterrorism practices and implementing effective disarmament, demobilization, and reintegration programs. However, there has not been a comprehensive assessment under the mandate of specifically how transitional justice tools can and should be applied in responses to grave human rights and humanitarian law violations resulting from terrorist activity and counterterrorism operations. Accordingly, I intend to develop recommendations for how transitional justice tools, including criminal accountability, reparations, truth-seeking mechanisms, reintegration practices, memorials, and institutional reforms can be leveraged most effectively in response to massive human rights and humanitarian law violations resulting from terrorism and counterterrorism. This process will also account for the specific challenges posed in applying a transitional justice approach to terrorism and counterterrorism, such as the stigma attached to former members of terrorist organizations and lack of international legal clarity created by the state obligations under Security Council Resolution 1373 to criminalize terrorism without the provision of a definition of terrorism. Second, I also aim to study the challenges posed by negationism and revisionism of past violations of human rights and humanitarian law, as well as the politicization or instrumentalization of transitional justice. This priority is a response to the recent rise of these trends, which has been facilitated by advances in information technology and the consequence of rapid spread of disinformation. Revisionism, negationism, politicization, and instrumentalization of transitional justice pose a serious threat to the field and to the people that stand to benefit from transitional justice processes, as well as serve as a major indicator of an imminent return to violence. They can be particularly tricky to address because of concerns about interrelated rights, such as freedom of opinion and expression. So it requires careful responses that are compatible with countries' full range of human rights obligations. In relation to counterterrorism, negationism, revisionism, politicization, and instrumentalization can be particularly dangerous as states use counterterrorism as a justification for engaging in unlawful, abusive behaviors towards groups that they seek to repress. Third on the list of substantive priorities is the issue of transnational transitional justice. As you know, from the counterterrorism context, conflict and authoritarianism rarely stay within their borders, and international armed conflicts in particular create far-reaching cross-border networks of harms and responsibility. Although it naturally follows that transitional justice efforts aimed at addressing these instances should also be transnational in scope, it can be extremely difficult to cultivate the international collaboration necessary to support such systems. The context of counterterrorism and terrorism adds interesting layers of opportunity and complexity to these challenges, but holds the potential to be an area in which transnational transitional justice could be particularly meaningful given the international terrorist networks and counterterrorism movements that have shaped global geopolitics for several decades. Turning now to the transversal priorities, which I will address in reports to the Human Rights Council each year, I would like to share with you two additional areas of interest that I think are especially relevant to the counterterrorism network or field. One of these areas is the study of transdisciplinary approaches to transitional justice. This priority is in direct response to the common critique that transitional justice has been overly legalistic field and reflects a strong belief that holistic, truly context-specific approaches to transitional justice require the incorporation of knowledge and practices from across the social sciences, applied sciences, arts, and humanities. As acknowledged, many of today's transitional justice contexts are grappling with histories of terrorism and counterterrorism, so it's especially important to have experts from the field involved in designing mechanisms and reforms to address related harms and prevent recurrences. The other area I would like to highlight is the role of emerging technologies in the context of transitional justice. The advancement of technology facilitates large-scale human rights abuses through more destructive weaponry and more sophisticated methods of repression and social control, such as through facial recognition technology, etc. However, emerging technologies also create opportunities for making documentation more accurate and transitional justice processes more inclusive or accessible through video conferences in particular. Both these positive and negative sides of technology will likely play a role in how actors engage in and combat terrorism in coming years, so it will be particularly critical to study this area for collaboration between our fields. In conclusion, I would like to recall that in preparing my reports to the Human Rights Council and to the General Assembly, I will launch a call for inputs, inviting for written contributions from experts like you, And similarly, depending on funding and partnerships, I hope to organize expert meetings which will also inform the preparation of the reports. So I hope that you will have the opportunity to contribute to these initiatives and discussions and continue to engage with the mandate. So I thank the organizers and my fellow panelists for facilitating this timely and important discussion, and I look forward to hearing your questions and comments. Thank you.
Thank you very much, Bernard, for sharing with us your presentation, for sharing with us these areas of interest that touch counterterrorism. And of course, I would like to renew our support to your mandate, and we will be very happy to give our insights also when it will be the time for you to write your report. And I would like now to give the floor to Anne, who will talk about some challenges regarding the interaction of these two fields. Thank you.
Thank you very much, Nikki, and good morning or good afternoon to all of you. I'm delighted to be here today to be able to address this important and emerging issue. And I want to start by thanking the ICCT for organizing this webinar, as well as by welcoming the approach of the Special Rapporteur, Mr. Duhem, on this issue. As the general framework has already been covered in the previous presentations, I'll limit my intervention to a few points that I think are important to bear in mind when addressing transitional justice in contexts where terrorism and counterterrorism are a part of the discourse. And the first issue I want to address briefly today is that of the legal frameworks. Transitional justice, as you all know, and as has also been noted, is rooted in international law, in international human rights law, and international humanitarian law. It's a subframe of and complementary to international law obligations. So the starting point of transitional justice is the binding international legal instruments. In contradistinction, the global regulatory counterterrorism framework that has been mostly developed over the past 20 years is both expensive and extensive. It has treaty, Security Council resolutions, and soft law aspects, and it depends on the national implementation of these various norms. It's also composed of a sanctions regime, or actually two sanctions regimes, one that is administered directly by the Security Council, and another one or other ones mandated by the Security Council and implemented at regional or at national levels. Although the counterterrorism framework remains, at least theoretically, subject to the overarching rules of international law, the regime is in fact grounded in exceptionalities, and it enables a range of military law enforcement and criminal law measures against individuals who are suspected of involvement in or accused of acts of terrorism, as determined by national authorities. So that's what I wanted to set out initially on the legal frameworks. Now, let me now turn to some analytical challenges that are linked to the use of the words terrorism in a transitional justice context. And the first issue I want to raise here is the question of the discourse and the qualification. How conflicts, groups, and individuals are qualified is key to understanding the challenges posed by the counterterrorism framework. The labeling of non-state armed groups as terrorist or as violent extremist, whether by the UN or by government, means introducing a generally permissive international framework that in fact empowers government action. As we all know, the continued lack of semantic clarity that pertains to the use of the word terrorism at the international level has very serious consequences on how this word is used at the national level. And overly broad and vague definitions of terrorism have allowed its misuse by government to stigmatize and delegitimize. Any extensive use of this term can lead to its use in numerous contexts and against numerous actors through an aggressively punitive lens, including through military and law enforcement action, which is often compounded by the provision of extensive tools and assistance by the international community. And what's more is that the use by governments of stigmatizing terms to qualify conflicts, groups, or individuals often remains wholly unchallenged by international actors. The reasons for this can be found in the need to preserve access, the implementation of programs, or simply protecting the sensitivities of a government. Yet unchallenged overbroad designations can have very specific repercussions on humanitarian actors, both in terms of access, but also in terms of provisions of aid and impartial, just generally impartial humanitarian action. But it can also impact on the work of human rights actors. So qualifying a party as terrorists and therefore repressive government action as counterterrorism is at the root of fundamental policy choices regarding the identification and the definition of the causes of the conflict or of crisis, and their management and their resolution. First of all, it imposes a unitary lens on harms and drivers. It provides a simplified analytical vision and framing that often does not grasp the complexity of conflict and crisis situations. It fails to generally understand that the factors and the causes of conflict may not inherently be caused by the designated group, and that the solution does not necessarily lie in the military defeat of the group, particularly as military or law enforcement approach to large terrorist groups has proven elusive at best. It increases the asymmetry between actors and locks them into a specific right versus wrong role, which leaves no room for challenging or reframing the initial analysis. Further, by locking actors into a security approach to addressing the drivers of the conflict, it reduces, if not entirely discards, the scope for political solutions and dialogue. It also reduces the possibility of addressing any responsibility of the government, of elites, of the law enforcement, or the military in contributing to grievances. By relying on existing institutions for the delivery of military and security objectives, international support to the counterterrorism effort can lead to support to failed security sectors implicated in human rights violations or the repression of political protest, torture, and corruption. And at the same time, such approaches can create incentives for government to nurture violent extremist and terrorist groups and conflicts to create or to justify an ongoing conflict and ongoing international support. As part of the unfolding logic of security responses to terrorist and violent extremist violence, with increased legitimacy and no incentive to open the political space, the state has the power to apply the full force of its security apparatus, while local populations and communities are caught between designated terrorist groups on the one side and overly militarized or abusive state responses on the other side, and they have few viable options for ending associations with the former. So just to sum up, militarized and securitized solutions and serious violations of human rights, which are often defining elements of counterterrorism in conflict contexts, do little more than sustain violence most of the time. And this risk is increased by the asymmetric nature of these types of conflicts that usually ouster the application of international humanitarian law. The second challenge I want to raise regarding the labeling of non-state armed groups as terrorist or violent extremists are the consequences on policy choices in terms of political solutions to crises, notably prosecution, punishment, and accountability, all of which have distinct consequences for the managing of complex, fragile, and conflict-affected environments. So I want to briefly illustrate this with 4 examples. First of all, prescription, then I'll turn to amnesty, prosecutions, and finally, the rights of victims. So on prescription, I want to say that the exclusion of terrorist and violent extremist groups from political processes is the result of various prescription regimes enabled by Security Council resolutions, whether that's directly at Security Council level or through national and regional implementation. And this is a core aspect of the multilateral counterterrorism framework. Yet, by affecting the way the conflict is portrayed and circumscribed, prescription impacts on the possibility of reconciliation as an objective and on mediation and negotiation efforts as part of a peace process. Prescription constrains the range of policy choices that are available, including the possibility of engaging in transitional processes themselves. Labeling individuals or groups as terrorists can itself be political or opportunistic. Yet once this labeling has been done and is established, it is extremely difficult to overcome. It aims to restrain the application of international humanitarian law, rule out participation in any political peacemaking process for years, all while rendering unlawful treatment of the group and its members more acceptable. Such labeling also often triggers the use of provisions that criminalize acts of support, including material support, and many civil society groups, including those engaged in mediation and peacemaking, find themselves constrained by such laws and by such labeling. On amnesty, in conflicts related as counterterrorism, the focus on prosecution for terrorist acts is such that amnesties are often off the table entirely, even for less serious crimes, such as belonging or membership. Now, it's clear that questions of membership and belonging or association are extremely complex questions, and they require nuanced approaches to the question of accountability. Approaches that cast the net too widely risk penalizing civilians who had little choice but to develop some association with terrorist groups, often the ones that are present in their village and communities, or even those who had no association at all. This can lead to further alienation and grievances and new cycles of violence or even revenge. So under, over, or inaccurate assessments based on indicators such as family ties, clans, religious affiliation, gender, age, can perpetuate or generate new grievances and marginalization, and can in turn undercut efforts to entice defection, rehabilitation, and reintegration, and can even in some cases lead to increased recruitment by the group. And as a final point on this is that any assessment of association should always take into consideration the possibility of coercion, which is rarely done. A word on prosecution. So the counterterrorism framework often comes with a prosecutorial strategy that focuses on criminal prosecution only for terrorist offenses. Now, this has serious consequences on the realization of the right to justice and on the fulfillment of the right to truth. This very narrow terrorism focus leaves a wide range of not terrorist, but very serious crimes unaddressed. Accountability is often only sought for a limited number of non-state actors, leaving out the responsibility and equal treatment across organizations and groups. The focus on the accountability of terrorist groups often excludes accountability of other actors, including state actors, for violations committed both in counterterrorism operations, but also and more broadly in complex conflict situations. The toll on the judicial system and on the carceral system can be immense. It's often wholly unprepared to deal with a large number of individuals charged with terrorism offenses. And it also uses limited resources on individuals who could benefit from alternative processes. Counterterrorism approaches also have an impact on the rights of victims, which is a key element of transitional justice, which includes a recognition that victims can take many forms in complex conflict situations. The counterterrorism framework however, is extremely limiting when it comes to the recognition of victims. Individuals victims of counterterrorism violence, individuals suffering from long periods of exclusion and discrimination, individuals only loosely associated with terrorist groups, or individuals themselves only allegedly linked to terrorism may not necessarily be perceived as victims in this context. So to conclude, I would highlight that transitional justice approaches to complex conflict situations characterized by the presence of designated non-state groups would fundamentally alter conflict analysis and resolution, would undoubtedly complexify the overly simple action-reaction narrative, and also address individual responsibilities, as well as issues relating to collective support, both for countering terrorism and for terrorist groups, as well as the situation of some communities who are victims of both. Understanding the internal motives and external factors that lead to crises and conflicts, including the use of terrorist violence, can assist in addressing the real or perceived grievances and needs of those engaged in the conflict situation, as well as help in identifying victims, which is often extremely complicated in a conflict tainted by the shadow of terrorism. And as a consequence of this approach, questions relating to justice and accountability would also, in my view, be addressed more holistically. Just maybe two final points. I would highlight the inherent difficulties of this approach, given the power of the counterterrorism narrative and the strength of the counterterrorism framework, and the funding that comes with it, combined with the reluctance of many national and international actors to refer to transitional justice processes. And the last point I want to raise, but that I'm happy to come back to, is the risk of instrumentalization of transitional justice by counterterrorism actors. That some selected aspects of transitional justice simply becomes another tool in the counterterrorism arsenal. I'll stop here, but I'm really looking forward to the questions. Thank you.
Thank you very much, and thank you for setting the framework, giving the different framework of transitional justice and CT, and also pointing out these challenges. I'm sure that we're going to have questions and we'll discuss further during the Q&A. I would also want to remind our participants that they can always put their questions on the Q&A. And I will give now the floor to Tanya, who will use her extensive experience in counterterrorism to comment the two presentations.
That is a huge challenge indeed. There are so many things to touch upon. So I'll try to reflect on a few points so that we also have some room for discussion. I would like to thank both the panelists for their presentations. A lot of food for thought and a lot to unpack. So, I mean, let me stress by saying I share the concerns of the over-reliance of a counterterrorism framework, especially in the context of armed conflicts, and also strongly underline the need to adopt a more transitional justice approach. So with respect to labeling, in addition to what Anne mentioned, the problems it causes when it comes to negotiations and mediation and amnesties, I think designating non-state armed group does not only have a negative impact on those aspects, but designating non-state armed groups can also lead to more violence and more civilian casualties because it removes the incentive for the non-state armed group to abide by international humanitarian law. So I think this is another negative impact we should take into account of designating non-state armed groups. With regard, what we see is very often mentioned is that also in the work and in the capacity building projects that we have done, that there is very clearly an underclassification of a non-state armed conflict by states, because then they do not need to apply international humanitarian law, so they think. But what we also see is sometimes an overclassification, of the war on terror. So we see both underclassification and overclassification of violent acts. So what I do think at the same time is if we focus a little bit more on the criminal prosecutions and the reliance on only terrorist offenses, I think that is not conducive for long-term peace and security. But we also have to be, cognizant of the fact that the reality is that in many conflicts which involve designated non-state armed groups, serious violations are indeed being committed by all parties to the conflict, including the states, which may not want to apply a more comprehensive criminal prosecutions. But what we also see is that several of these countries have not criminalized or implemented core international crimes. Examples include Syria, Iraq, Afghanistan, and Nigeria. And while some countries are in the process of criminalizing these offenses, these cannot be applied retroactively. So this would mean that a different approach to accountability is needed. And I think that this is the area where we need to explore that, not only looking at prosecution solely relying on terrorist offenses, but we do need to refocus and also look at cumulative charging, and that it would also allow for prosecutions in some countries where it is possible for core international crimes, but in other countries looking for cumulative charging for terrorist offenses and domestic offenses. A clear example is a recent case in Nigeria where a member of Boko Haram has been prosecuted for a terrorist offense, but the underlying act were sexual and gender-based violence crimes, which were acknowledged as causing bodily harm. In addition to that, I think it is important to see how counterterrorism and transitional justice can be leveraged in a way that it is mutually reinforcing to advance justice and accountability. So in addition to exploring and strengthening the concept of cumulative charging, I think it's also important to refocus on prosecutorial discretion when it comes to crimes with a terrorist element. And this means prioritizing cases, but also focusing on the criminal principle of ultima ratio, that there would be a restraint to prosecuting certain crimes which do not amount to a significant harm. And this is in particular relevant in cases where you see that prosecutions are taking place for membership offenses, where you don't see there is a clear role and participation and contribution to the terrorist aim. And furthermore, I think victim participation in counterterrorism prosecutions needs to be strengthened. So these are just a few points that I wanted to raise where I see where there are maybe possibilities how counterterrorism and transitional justice can be mutually reinforcing. And while we focus a lot now on counterterrorism as one of the aspects, mainly on criminal prosecutions, but I think it would be also good to explore other areas of counterterrorism. For example, the experience that some countries have gained with rehabilitation programs, both in and outside of prison, and how to continue this process. And I think this is an area which would be interesting to explore how this could be of useful to transitional justice. And I think the other area where it could be interesting to look at, and that is more on the prevention side, is where you see, for example, programs which are being developed for youth, both offline and online in schools, where they're focusing on preventing polarization, encouraging dialogue. And I think there is also an area which could be further collaboration and can be explored between transitional justice and countering terrorism. I will leave it at this for now in light of the time, so that there is still some time for questions from the participants, but also for the panelists to respond.
Thank you very much, Tanya. And I would like to remind to our participants that they can pose their question in a Q&A session, which is in the button. So please feel free to address any questions you have to our panelists. And maybe I will start with a first question. I see questions coming. So I'm going to just do a very short myself, and then I'm going to go to the questions. I have been actually drafting now an article about an edited volume that will be published with ASER, and it's on the topic of transitional justice and counterterrorism. And one of the challenges I have been encountered is if you start the transitional justice process and you have a Truth and Reconciliation Commission, there is the problem of when engaging terrorism in the transitional justice process to have the risk of legitimizing them as interlocutors. So I was wondering if you can reflect on how we can overcome the challenge when, for instance, in the Truth and Reconciliation Commission during a hearing, it can be also a space of sharing ideology on radicalizing others or accusing the justice of the state. So how can we try to minimize a challenge like this, giving the space to someone to talk further about an ideology? So maybe Anne or Bernard.
Thank you, Nikki, for this excellent question. So, well, I mean, as I mentioned earlier, we're at the beginning of the process of, thinking about these issues, and I think this is exactly the type of challenge that we'll be looking for addressing in the reports when we deal with this matter. Your question also refers to not only legitimacy but also the right of individuals to express views in these processes, and this is as always a challenge in truth-telling processes. Do we want to have a pre-packaged truth, and what's the limitation of the types of truth that we are interested in? I think looking at recent examples or ongoing examples, the JEP in Colombia is a good example where FARC agents are participating in the truth-telling exercise as well. They have been qualified as terrorists. They have been qualified also as parties to a non-international conflict, depending on the points of views in the past. But I think if it's done in a proper way, and it's structured, and the process is well organized with the proper authority micromanaging the discussion. It can be done in a useful way. But again, we are just starting the process of thinking of those issues. So that's exactly the type of element that we'll be looking at when we prepare our report on this. Yeah, thanks.
Thank you, Bernard. And as you mentioned, the Colombia case, there is a question that maybe Anne can give us some insight, which I will read it from the chat. It's in the Q&A, and if you also want to have it written, it says, could you assess the impact of the terrorism designation on transitional justice processes in contexts previously identified as counter-terrorism, such as Colombia?
So I'm not a specialist on Colombia. I have not worked extensively on this part of the world, but just I think more generally on this question. I think I'd start off by saying that military victory in complex armed conflicts is often not a realistic prospect. And so negotiation and mediation should not be completely off the table. And again, I mean, Colombia has been mentioned, but I would also mention Spain and also Northern Ireland as examples where these processes were engaged and did work. So of course, full reconciliation with some terrorist groups will be absolutely impossible due to their absolute unwillingness to abandon violence and their lack of respect for the most basic principles of international law. I do think that partial or even conditional negotiations should not be completely off the table and should be an option, including for specific issues such as ceasefires, prisoner treatment, application of humanitarian law. This can all reduce violence and assist civilians that are caught in a conflict, and they can serve as building blocks towards a more comprehensive solution in the future. And I would also just maybe to a final note on this question is to say that this kind of more nuanced approach is clearly in line with the global counterterrorism strategy of the United Nations, particularly Pillar 1, which notes that the peaceful resolution of prolonged conflicts would strengthen the international fight against terrorism.
Thank you, Anne. And we have a series of questions. Let's go to another one. I would say, what are some potential human rights risks associated with multinational military alliance like NATO in counterterrorism, and how might transitional justice principles address this risk without compromising operational effectiveness? And maybe Bernard, you would like to jump on this?
Sure. Well, human rights risks associated with alliances. I mean, off the top of my head, I would say that one of the risks is trying to identify the duty bearers in these processes. So, states have international human rights law and humanitarian law obligations when at all times, human rights law obligations at all times and humanitarian law obligations during armed conflicts. And the fact that states operate under a different hat or helmet, so to speak, does not alter this. And my worry is that sometimes, whether it's multilateral or regional, operations, the identification of the duty bearer is diluted or misunderstood, and the danger to this is that the responsibility and the duties that go with those obligations, including reparation, is often passed to the neighbor rather than being assumed both by the states and the multilateral or regional structure that that oversees these operations. So I think it's really important that in the terms of reference where these initiatives are undertaken, it's clearly established that the state agents can in their actions include or involve the responsibility of states, and that individuals always have their international criminal responsibility at play in those circumstances as well. So I hope this is a first step in answering the question. Thank you.
Thank you. Tanya, yes.
Yeah, maybe just to add, on the individual criminal responsibility, that I fully agree with Anne. I think especially membership offenses is very, not helpful. Also in the context of setting an historical record. It doesn't address the underlying acts that have been committed, and it doesn't acknowledge enough the distinction between voluntary and involuntary membership and violent and non-violent contribution to a terrorist group. Sometimes it's also only purely by affiliation and by marriage. So I think it is important when we are talking about individual criminal responsibility that we try to focus as much as we can on the underlying criminal act that has been committed. And as mentioned, that could be sometimes achieved by looking at domestic crimes, but it could also be by adding aggravated circumstances if there is the possibility to prosecute for core international crimes. My concern is a little bit if there is no willingness to engage by certain countries in transitional justice approach. I wonder, what their willingness would be to also have or adopt, core international crimes, which would also allow for criminal prosecutions for the full extent of crimes that have been committed, not only by the non-state armed groups, which may or may not have been designated, but obviously also which have been committed by states themselves.
Thank you. And maybe I will proceed with another question. How would transitional justice and the presentations relate to the Al-Hol detention as a result from the anti-ISIS coalition's actions? What would be recommendation to the members of the coalition? I'm wondering whether, Anne, you can attempt to reply this question.
Sure. So maybe I want to start by saying that not just Al-Hol, but the whole situation in Northeast Syria is one where there is absolutely no application of international law. There are numbers are very approximative, but there are between 50,000 and 70,000 individuals, men, women, children, detained in what is essentially a complete legal black hole. The camps, Al-Hol and Raj, contain the majority of women and children. Over 60% of that population are children, and 80% of those children are around the age of 12, 13. So we are talking about the largest place of detention of children for counterterrorism purposes anywhere in the world. Maybe just a word about the prisons. There are approximately 15,000 men who are detained in quite a large number of detention centers, some larger, some smaller, including some that are supported by the international community. Some of them have even been built by the international community, such as Panorama Prison. And none of these individuals, not a single one of them, has ever been brought before a judge. Most of them are not charged, or at least do not know they have been charged. Many of them have been stripped of their citizenship. and they have no way out except by the repatriation of their states of nationality. Boys around the age of 12 are violently taken from their mothers and placed in so-called rehabilitation centers, which are another form of detention centers, because again, there is no legal basis for the detention. There is no legal basis and no assessment of their best interest when they are taken away from these places. And most of them are held in places where they are in cells for 23 hours out of 24 in a day. The Special Rapporteur, the former Special Rapporteur on Human Rights and Counter-Terrorism, was able to carry out a visit to the region last summer. This was the first time that an independent human rights expert was able to go and look at places of detention. I accompanied the Special Rapporteur on that visit, and we issued quite a detailed end of mission statement and a report to the General Assembly, which was also the former Special Rapporteur's last report to the General Assembly. So that's by way of background as to what is happening in Northeast Syria. Now, I would be very, I mean, I'm going to let the Special Rapporteur speak to the transitional justice aspect of this question. But I think before even we look at transitional justice processes, we should just be looking at plain justice processes, which at the moment is completely absent from what is happening in Northeast Syria. These individuals have now been detained for more than 5 years. So I'll stop here.
Would you like Bernard to add something in the question, like the transitional justice approach?
Well, I think Anne has raised the most important element, which is the issue of legality and due process in these circumstances, and unfortunately it's not an isolated case. In my previous capacity as a member of the working group on enforced disappearances, we've also been in country visits where there were allegations of the existence of camps for former foreign fighters and for their families, for their children, for their spouse and so forth, and these instances were characterized in the exact same way, kind of a black hole without any due process, and very disturbingly, no national oversight, but no international oversight either, and the quantity of children in those types of conditions is increasing, and so yes, I think that as a matter of emergency, the basic rights of the persons who are in those conditions have to be looked at, and that there needs to be some form of oversight. It cannot be a system of perpetual exception, and it's not I mean, this is becoming unfortunately more the rule than the exception, and it's not just regarding to former ISIS individuals. If you look at all across the world, the way that organized crimes is addressed in certain circumstances has a similar raises similar concerns. So I mean, for me, the comment that Anne made with respect to the fact that we should start by looking at first at the legal obligations and the human rights of the persons in these conditions, first from a strictly legal human rights point of view, also raises the broader question that I want to look at when I will address massive human rights violations and the relevance of adopting a transitional justice perspective, dealing amongst other topics with terrorism and counterterrorism, but also migration and forced displacement and environmental crimes and corruption and organized crime, is the issue of whether and how transitional justice processes, norms, principles, institutions, best practices can be or should be applied in these contexts, and whether it can be and how it should be looked at. I don't think it's wise to just take transitional justice, the framework, and just paste it to these situations, irrespective of the context-specific requirements. I think each context is specific. I think the idea of the study that I want to do when I address this issue to the General Assembly is not just to look at each specific subtopics, but mostly to look at whether and how transitional justice can be, from a macro perspective, applied to those situations, and why and how that will, in general, require a lot of analysis and discussion. It's I'm convinced that transitional justice has contributions to make, but the danger of just pasting transitional justice solutions or frameworks to these situations is the one that Anne was also referring to, the instrumentalization of transitional justice and using the label of transitional justice to either sort of greenwash a process that is in violation of human rights, due process standards, and other guarantees, detention conditions that violate human rights obligations, and so forth. But also not only to greenwash, but also to give legitimacy to a state of fact, a de facto situation where state authorities have taken certain extreme measures. So I think it's important to think how transitional justice is useful and relevant, but one needs to be careful not to just do it in a amateur and naive and candid way, because it can be exploited, it can be instrumentalized, and I think recent history shows that sometimes transitional justice is more used as a label than a sincere process to ensure the rights of victims and to ensure reconciliation in a new society project that is offered by the authorities. Thanks.
Maybe, just to add, to Bernard and Anne on the whole, clearly there is, no legal basis, but I think what we also the prolonged stay of the women and the children is also, hindering their reintegration in the long term back. And what we have also seen in those rare cases that women and children are being repatriated to some of the European countries, that courts are in fact taking into account the time that they have spent in the camps, and it is reduced from their sentence. What we see is also that there are like multiple traumas from the time that they have spent with ISIS, but also from the time they spend in the camps, and also the repatriation process itself. So the longer they are staying, that this is also only compounding the problems once they will be repatriated and reintegrated. So I think that is also something to take into account, what we see happening in several countries, and the fact that there are also people in the camps, with different affiliations, which is also making it very problematic. On your point on the greenwashing, I think that's a very valid point. But to be honest, I don't have an answer to that. like, how could we prevent that it is just going to be used as a label? I do not know whether there are like criteria or tools that you can maybe measure, that how, I do not know whether there are like, monitoring and evaluation mechanisms available and are being used in transitional justice processes. That's an honest question from my side, that I'm wondering whether that is a way to ensure that it is not just simply used to whitewash. So if a country would say, yes, we are open to transitional justice, whether an M&E mechanism could help ensure that it is really used for the right purposes. So just keen to hear your experience also on how do you measure the impact of transitional justice in your experience.
If I can just jump quickly on that, well, a good indicator is certainly whether the entire context is taken into consideration in truth-telling and justice-related initiatives, and are not just targeting one or addressing one side of the story. We are actually currently in the process of launching a call for input on documenting human rights violations and violations of humanitarian in post-conflicts or post-authoritarian situations, precisely because, unfortunately, in some of these processes, there's been very biased and partial approaches to these processes, which create very incomplete historical narratives to situations, and perpetuates frustrations and can eventually generate additional trouble and violence. I think one needs to be very careful about the danger of this labeling, in part because unfortunately funders will sometimes request that these processes are looked at as a solution. I'm not saying that they shouldn't be a solution, but if the intention needs to be a genuine society project rather than just satisfying an audit that a funder is providing or asking for in order to unlock some resources. And unfortunately, I'm afraid that it's sometimes the case. Similarly, transitional justice processes cannot be alternatives for dysfunctional judicial processes that are required. So, one cannot say, well, so many people and our justice system is already overloaded and dysfunctional, and so we won't be able to do trials, so we won't do trials, we'll just do a quick truth commission, amnesty everyone, and that will be it, because we can't do anything else, because our justice system is dysfunctional. That's one of the dangers that I'm worried about when thinking of labeling transitional justice and the instrumentalization of transitional justice. But there's tons of examples. When we will address these issues in the report on negationism, revisionism, politicization, and instrumentalization of transitional justice, we'll go deeper into each of the possible scenarios. But I think the danger is very real, and I think it's occurring in certain parts of the world currently.
Thank you. And I will go to another question as the time is running. There is a question saying, it was explained to us that the label of terrorism represents a serious risk of criminalization of dissident groups. Are there actual cases of transitional justice where terrorist groups have participated? And maybe Anne, you can start with the question.
So again, I think I'd start by saying again what I was saying about the labeling of terrorism. The labeling of terrorism, because the counterterrorism framework has been so expansive, and the Special Rapporteur mentioned Resolution 1373. I'm not going to get back into that, but there seems to have been a push for the use of this framework, both by the Security Council, but more generally by the United Nations, which was very much welcomed by many governments around the world, because this allowed them to use this repressive framework without having any definition of who a terrorist was, and national definitions. And if for anybody who's interested, there's lots of legislative reviews that we have that have been carried out both through communications, but also through country visits by the Special Rapporteur. And I know that the current one is doing the same, that show that definitions of terrorism are overly broad, overly vague, and have been abundantly misused throughout the world to qualify a range of civil society actors, political activists. Maybe this would be putting it too broadly, but anybody that the government does not like. And so clearly there's also been a push in this context for conflicts to be requalified as well. So conflicts, even pre-existing contexts, conflicts that existed prior to 2001 were then relabeled as terrorism conflicts, which enabled the government to be doing the right thing vis-a-vis international law, and certainly do it with much less scrutiny than they would have done otherwise. So I think this is my starting point on the question of the misuse of the label of terrorism and the criminalization of dissent. I think that's what I would like to answer to that question.
If I can add to the excellent answer of Anne, these are not issues that are new today. Oh my God, we're finding out about these problems. This has been, amplified, of course, in the past 25 years because of 9/11 and so forth. But if you look at the 2002 report by the Inter-American Commission on Human Rights, a report commissioned by the General Assembly of the OAS at the time, a lot of these problems were addressed in great detail, of course, within the legal framework of the Inter-American human rights system, looking at the case law and jurisprudence and principles developed in the Inter-American Court of Human Rights and Inter-American Commission of Human Rights regarding attitudes of states which were fighting terrorism or allegedly fighting terrorism, or labeling opponents as terrorists, or labeling whomever they weren't, in agreement with, in particular in authoritarian contexts. So this is not something new that we are discovering. The discussion has been going for decades, and it's in part because of the, as we're saying, I wouldn't say carte blanche, but the danger that, that the debate has generated by, painting good guys, bad guys, and the states doing what they need to in extreme circumstances. And I would say also the way that pop culture also has entertained this whole situation through the media, often dilutes very basic principles of human rights law, but just of law in general, principles of legality, you know, precision of legislation and non-retroactive applicability of laws and so forth, that I've been here, I've been, you know, on the table for several years, and I think it's important that human rights experts, legal experts in general, reiterate those principles and reiterate those findings, because obviously there's a lot of there's a lot of ignoring going on when addressing these concerns, as if there were optional principles that the states can pick and choose from, when it's a legal obligation, and in certain circumstances, you know, imperative norms of international human rights.
Thank you. Maybe a last question for Tanya this time. There is a question in the chat saying, has reception for integrating transitional justice been well received by international counterterrorism? I'm curious if reduced or augmented sentences from criminal proceedings would be possible in the counterterrorism framework as one option.
Now, I think the first part, if it is more about, you know, the international actors, I mean, like within the UN, I think that's maybe more something Anne would be able to say more. Also, she specifically mentions it in her report, but I was intrigued by the comment on reduced sentencing, and I think that is an interesting suggestion offered. And what we see is that a lot of times in countries there is no, the sentences are not reflecting the gravity of the crime that has been committed. And just to give you an example, like, I mean, in Iraq, the same penalty is being given, death penalty or 30 years, and you're not taking really into account what kind of contribution someone actually has made to this terrorist organization. But I think also in European countries, I think more research is needed in whether or not reduced sentencing is a possibility. I mean, and I have seen instances where this is being done, but there's not like a general policy on that, but like whether they actively would participate in a rehabilitation program, even already while being in pretrial detention, awaiting the trial till the trial is completed, or after conviction. So I think this is an area which I think it should be further explored, and more research is needed to see how, if terrorism trials are going to be still used in the context of these kind of violations, it would at least reflect a little bit more the gravity of the crimes. So I think this is a good way of ensuring that. So I think that is a good point raised.
Thank you, Tanya. And as we're approaching the end time, I would like to ask to Bernard and Anne if they have some last comments regarding the different issues that they were raised.
No. Well, I agree with what Tanya said on the last question. I mean, I've just started in May, and since I've been in discussions with several UN entities who are interested in exploring these perspectives of transitional justice in context of counterterrorism. And so far, the approaches that I've suggested, again, it's just announcing that this is an area of interest, has generated a lot of interest and has been welcomed quite in a positive manner. So I think that's encouraging, but also very telling as far as the relevance of the topic. As far as the issue of sentencing, I mean, this is always a tricky question because the sentencing has to reflect the gravity of the crime and also be done in accordance with the victim's rights to justice. There are some good practices and good examples that we can look at. There are unfortunately a lot of less of bad examples or not as good as examples, but you know, again, looking at my past experience at the working group on enforced disappearances, the 2006 Convention on Disappearances expressly refers to the possibility of considering the contribution of the accused in locating the disappeared person or his or her body. So that's a concrete contribution to the rights of victims to truth and to reparation that the accused person is doing. So I think looking at this balance between the rights of victims and of the accused in these sentencing processes and how the accused person is contributing to these processes, it can be taken into account, always, of course, keeping in mind the gravity of the crime and not diluting this gravity in some form of alternative justice process. I take this opportunity again to thank the organizers for inviting me. I think this is a very stimulating discussion, and I hope it's just the beginning of further engagement with the mandate. I invite all of you to reach out to continue this discussion. Thank you.
Thank you a lot, Bernard. And maybe Anne, some last words.
No, I don't have anything of substance to add on any of the last issues, but I also want to thank you for organizing this this conference and for inviting such an amazing person that the new Special Rapporteur is. And I really welcome again his approach. I think it's very, very welcome and needed at this time.
Thank you all for being here, for your presentation. And thanks a lot our participants online for their questions. I would like to say that the two reports of Bernard will be shared with participants, and also Anne's report on transitional justice in contexts that counter-terrorism is part of the discourse, so that you can also read them in your when you are at your place. Also, there will be a survey, so please feel free to give any feedback so that we can take it, our communication team can take it into consideration for future events. So thank you very much. I'm very happy for these conversations, and I hope we will be able to support Bernard's mandate. Thank you.